School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 6 Business and Sustainability, Unit 12 Environment Protection and Sustainability, Part 2.
Implementation, compliance, and enforcement. Good governance requires the establishment of viable institutions with adequate powers and competent personnel with the knowledge and means to deal with challenges while keeping public interest in mind. This is especially true in case of environmental pollution, which requires specialized scientific knowledge while dealing with various aspects of pollution. Tata Institute of Social Sciences, in a report published in 2013 titled Environmental Regulatory Authorities in India, an Assessment of State Pollution Control Boards, observed that, and I quote, "Time and again across state governments have not been able to choose a qualified, impartial and politically neutral person of high standing to this crucial regulatory post. The recent appointments of chairpersons of various state pollution control boards like Karnataka, a senior BJP leader, Himachal Pradesh, a Congress party leader and former MLA, Uttar Pradesh, appointed on the recommendation of SP leader, Arunachal Pradesh, a sitting NCP party MLA, Manipur Pollution Control Board, a sitting MLA, Maharashtra Pollution Control Board, a former bureaucrat, are in a blatant violation of the Apex Court guidelines." Unquote. Further, Supreme Court in the case of Teki Tagi Tara versus Rajendra Singh Bhandari highlighted that state pollution control boards or SPCBs constituted under the Water Prevention and Control of Pollution Act 1974 and the Air Prevention and Control of Pollution Act 1981 possess only a few or sometimes none of the attributes of good governance, and again a few or none of them are adequately empowered. It further stated, this is a serious problem afflicting the SPCBs for at least 2 decades if not more. Moreover, as per the NCRB data of 2020, a total of 589 cases were registered under Water and Air Act throughout India. Further, under Environment Protection Act, a total number of 992 cases were registered all over India. Even though it's a substantial increase in the number of cases from 2019, still there is a long way to go in order to ensure protection from environmental pollution and determining the liability of individuals and other such industries responsible for environmental pollution. Thus, even though India has necessary provisions regarding protection of environment in the form of legislations and detailed rules, still issues regarding its implementation, compliance, and enforcement have not been resolved entirely. Judicial forums in India have tried to resolve these issues to a certain extent. Judicial forums on environmental protection and liability of corporates. The judicial forums in India, primarily the Supreme Court and the National Green Tribunal, have played an important role in providing environmental protection and determining the liability as well as damages for environmental wrongs. Supreme Court. Over the years, Supreme Court has developed a rich jurisprudence pertaining to environmental law and policy in India. it has been the endeavor of this court to promote and imbibe the principles of international environmental law such as precautionary principle, polluter pays principle, and sustainable development within the domestic jurisdiction and endorse environmental sustainability. The court has on several occasions directed the violators to pay hefty fines, which acts as a deterrent against future violations and also results in better enforcement of the law of the land. The Honorable Supreme Court in the case of Indian Council for Enviro-Legal Action versus Union of India stated that, and I quote, "The polluter pays principle demands that the financial cost of preventing or remedying damage caused by pollution should lie with the undertakings which cause the pollution or produce the goods which cause the pollution." Unquote. Similarly, in the case of Vellore Citizens Welfare Forum versus Union of India, the Honorable Supreme Court defined the polluter pays principle as, and I quote, "Polluter pays principle has been held to be a sound principle. The polluter pays principle as interpreted by the Supreme Court means that the absolute liability for harm to the environment extends not only to compensate the victims of pollution, but also the cost of restoring the environmental degradation. Remediation of the damaged environment is part of the process of sustainable development, and as such, the polluter is liable to pay the cost to the individual sufferers as well as the cost of reversing the damaged ecology. Apart from the constitutional mandate to protect and improve the environment, there are plenty of post-independence legislations on the subject. In view of the constitutional and statutory provisions, it must be held that precautionary principle and the polluter pays principle are part of the environmental law of the country." Unquote. While dealing with varied environmental issues in the country, Supreme Court has never shied away from developing new principles of liability in accordance with the changing times. On the issue of determining liability of enterprises engaged in hazardous or inherently dangerous activity in the case of M.C. Mehta versus Union of India, Supreme Court developed the principle of absolute liability and refuted the rule of strict liability as adopted in the case of Ryland versus Fletcher. The court stated that, and I quote, "An enterprise which is engaged in a hazardous or inherently dangerous industry which poses a potential threat to the health and safety of the persons working in the factory and residing in the surrounding areas owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous nature of the activity which it has undertaken." Unquote. Further, in the case of Indian Council for Enviro-Legal Action versus Union of India, the court examined the grave pollution of a village caused by the trial run of certain rogue industries and held that it was a case where principle of absolute liability for damages shall be applied. Moreover, in the case of Kamal Nath versus Union of India, while adopting public trust doctrine, Supreme Court highlighted the difference between damages and exemplary damages that offenders are required to pay and imposed a fine of rupees 10 lakh as exemplary damages. It stated that, and I quote, "A person who is guilty of causing pollution has to pay damages or compensation for restoration of the environment and ecology. He has also to pay damages to those who have suffered loss on account of the act of the offender. In addition to damages aforesaid, the person guilty of causing pollution can also be held liable to pay exemplary damages so that it may act as a deterrent for others not to cause pollution in any manner. The considerations for which fine can be imposed upon a person guilty of committing an offense are different from those on the basis of which exemplary damages can be awarded." Unquote. Thus, the apex court and the high courts can and do impose exemplary damages for causing harm to environment. In Sterlite Industries case 2013, the copper smelter plant was found to be operating without a valid renewal of its environmental consent to operate. The Supreme Court, in assessing the company's liability to pay damages, reviewed the company's annual report and determined that 10% of profit before depreciation, interest and taxes, that is, PBDIT, had to be paid, which amounted to INR 1 billion. In its effort to promote environmental justice in India, Supreme Court delivered a landmark judgment wherein it was argued that statutory tribunal like NGT does not have a suo motu powers, as only constitutional courts can exercise it. However, court, while stressing on the importance of NGT in dealing with environmental issues in this contemporary era, stated that, and I quote, "NGT was conceived as a specialized forum not only as a like substitute for a civil court, but more importantly to take over all the environment-related cases from the High Courts and the Supreme Court. Many of those cases transferred to the NGT emanated in the superior courts, and it would be appropriate thus to assume that similar power to initiate suo motu proceedings should also be available with the NGT." Unquote. National Green Tribunal. National Green Tribunal, or NGT, was established as a statutory tribunal in the year 2010 with the objective to make environmental justice accessible, effective, and expeditious in India. Since its inception, it has played an important role in determining the liability of wrongdoers and providing swift justice to the aggrieved parties. Realizing the lack of enforcement of environmental framework and the unwillingness of state pollution control boards to act against industries and other such perpetrators, NGT, in the case of Paryavaran Suraksha Samiti and ANR versus Union of India and others, YD order dated 3rd August 2018, stated that, and I quote, "The Central Pollution Control Board may take penal action for failure, if any, against those accountable for setting up and maintaining STPs, CETPs, and ETPs. Central Pollution Control Board may also assess and recover compensation for damage to the environment, and the said fund be kept in a separate account and utilized in terms of an action plan for protection of the environment." Unquote. Further, in the case of Praveen Kakkar and others versus Ministry of Environment and Forest and others, YD order dated 8th January 2019, the tribunal stated that, and I quote, "The Pollution Control Board has failed to perform its duties in taking statutorily mandated coercive measures under Section 31A of the Air Prevention and Control of Pollution Act 1981 and 33A of the Water Prevention and Control of Pollution Act 1974, or initiating prosecution. This tribunal directed CPCB to exercise its statutory powers to determine and recover damages for violation of environmental norms by the respondent therein." Unquote. In view of the directions issued by the NGT, CPCB has started maintaining an environmental compensation fund. It has also constituted a committee in order to manage the said fund. Further, specific guidelines on calculation of environmental compensation to be imposed on perpetrators have been issued in line with the orders of NGT. It is to be noted that penalties have been drastically increased under NGT Act. Under Section 26, Clause 1 of the Act, the tribunal can award punishment up to 3 years or fine up to 10 crores for non-compliance of order of NGT. Thus, the proactive nature of NGT with respect to the preservation and conservation of environment in India has led to the development of a practical regime of fines and environmental compensation in line with polluter pays principle for various types of offences such as illegal mining, wrongful disposal of waste including hazardous waste, air pollution, water pollution, etc. It has resulted in better enforcement of environmental laws and has acted as an effective deterrent against future violations. Climate change and India. India launched its National Action Plan on Climate Change in 2008. India has been a leading host country of clean development mechanism investments, enabling Annex 1 countries to invest in emission reducing projects, thereby earning certified emission reductions. India has emerged as second largest beneficiary to China in CDM projects. Its share in CDM projects is around 20%, China is 50%, and share in CERs is 13%, whereas China has 60%. The opportunities of CDM in energy sector, electric vehicle sectors are many. India submitted its intended nationally determined contribution in October 2015, which gives an outline of post-2020 climate actions that the country shall take. India is a founder member of the International Solar Alliance launched in 2015 itself. Recently at COP26, India made announcement of new climate action targets and has indicated that it shall be carbon neutral by 2070. Schemes, fiscal policies, and market-based measures. India is one of the fastest growing economies of the world. Indian government has initiated several measures in the form of policies, schemes, etc. in order to promote sustainable production, consumption, and also providing better and clean technologies to industries. Some of these are: number 1. Perform, Achieve and Trade, that is PAT scheme. It is a flagship program of Bureau of Energy Efficiency under the National Mission for Enhanced Energy Efficiency, that is NMEEE. PAT is a multi-cycle program started in 2012 with the objective to reduce the specific energy consumption in the most energy-intensive industries in the country. While the legal standing was built through the amendment of the Energy Conservation Act 2001, the operational artifacts were largely built around the principles of market-based mechanisms. It identifies sectors and designated consumers within such sectors and awards overachieving consumers with energy-saving certificates which could then be traded on Indian Energy Exchange. Number 2. Green bonds. Green bonds are the bonds issued by any sovereign entity, intergovernmental groups or alliances, and corporates with the aim that the proceeds of the bonds are utilized for projects classified as environmentally sustainable. As of February 12, 2020, the outstanding amount of green bonds in India was 16.3 billion US dollars. India issued green bonds of about $8 billion US since January 1, 2018, which constituted about 0.7% of all the bonds issued in the Indian financial market. Although the value of green bonds issued in India since 2018 constituted a very small portion of the total bond issuance, India maintained a favorable position compared to several advanced and emerging economies. Number 3. Securities and Exchange Board of India (SEBI). In 2012, SEBI mandated the top 100 listed entities by market capitalization to file business responsibility reports or BRR as part of their annual report as per the disclosure requirement emanating from the National Voluntary Guidelines on Social, Environmental and Economic Responsibilities of Business, that is, NVGs. The requirement for filing BRRs was progressively extended to the top 500 listed entities. Further, on March 25, 2021, SEBI has introduced Business Responsibility and Sustainability Report, which requires top 1,000 listed entities by market capitalization to mandatorily disclose resource usage, air emissions, waste management, and compliance with EPR and PAT scheme. Number 4. Micro, Small and Medium Enterprises or MSME. MSME sector in India is one of the largest contributors to manufacturing, provides employment to millions of people and is considered to be the backbone of our economy. However, most of the industries in this sector are still using first-generation technologies, which result in high pollution levels and low productivity. In order to promote new and green technologies in this sector, government has adopted several schemes and policies, such as number 1. Zero Defect, Zero Effect, that is Z classification scheme. It is an extensive drive to create proper awareness in MSMEs about Z manufacturing and motivate them for assessment of their enterprise for Z and support them. After Z assessment, MSMEs can reduce wastages substantially, increase productivity, expand their market as IOPs, become vendors to CPSUs, have more IPRs, and develop new products and processes, etc. Number 2. Scheme for Promoting Innovation, Rural Industry and Entrepreneurship, that is ASPIRE. It was launched to set up a network of technology centers and incubation centers to accelerate entrepreneurship and promote startups for innovation in agro-industry. Number 3. Credit-Linked Capital Subsidy for Technology Upgradation or CLCSS. The objective of the scheme is to facilitate technology upgradation in MSEs by providing an upfront capital subsidy of 15% on institutional finance of up to Rs 1 crore availed by them for induction of well-established and improved technology in the specified 51 subsectors or products approved. Important developments. Concept of corporate social responsibility. The 2013 amendment to the Companies Act introduced the significant concept of CSR as a practical regulatory measure, but nothing concrete was referred to environmental protection that emerged as a nominal component. There needs to be efforts made to develop a supplementary concept of corporate environmental responsibility in India. Environmental audit. It is not mandatory, but some states such as Gujarat, Maharashtra and Karnataka offer incentives to industrial units obtaining an ISO certification. The incentives are longer validity period of consent authorization, expeditious clearance of renewal applications, etc. These efforts need to be coordinated at the national level to provide the necessary catalyst to develop sustainably. Now let's summarize the unit. In the past 50 years, the world has developed ample understanding on the relationship between human beings and environment. The Stockholm Declaration adopted at the United Nations Conference on Environment in Stockholm 1972 placed environmental issues at the forefront of international concerns and marked the start of a dialogue between industrialized and developing countries on the link between economic growth, the pollution of the air, water, oceans, and the well-being of people around the world. India's approach towards environmental protection was piecemeal and reactive in nature. In response to Stockholm Declaration 1972, Air Prevention and Control of Pollution Act 1981, and Water Prevention and Control of Pollution Act 1974 were introduced. Further, Article 48A and 51G were incorporated in Indian Constitution by way of 42nd Amendment in 1976. The judicial forums in India, primarily the Supreme Court and the National Green Tribunal, have played an important role in providing environmental protection and determining the liability as well as damages for environmental wrongs. India is one of the fastest growing economies of the world. Indian government has initiated several measures in the form of policies, schemes, etc. in order to promote sustainable production, consumption, and also providing better and clean technologies to industries.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.